Heyo! And yes, Mads. Bit of boomerang. Yeah, as per usual. Nicotine pouches, something to drink. And it's Friday afternoon and time for an update regarding the Delphi case. If you are completely new with the Delphi case, Richard Allen is accused of the brutal murder of 2 preteen girls. And that's about it. Except that it has so much effery in it. The endings happened in 2017. They showed the police put out a poster which of a suspect, which is the person to the right. Then basically nothing happened for 2 years when they said, no, we are looking for the person on the left here. By that time, they had published a series of photos and some kind of voice recording of somebody saying, not very verbatim, but something in the style of down the hill. That was a series of photos or a video. I'm not entirely sure how everything went, because from the start they only showed a still or a picture of a person, And then all of a sudden it became a 4-second video, and then they put the sound on top of that. So people nowadays keep thinking that, well, it is the person on the bridge that says these words, but these are two separate occasions, not very much time in between, but it actually don't say or prove that the person on the bridge is the same person who says the words. And then nothing again. For 2 years, 2019, Richard Allen is arrested. No, sorry. Then it was, let's see, 2 years up to 2019, and then additional 2 years up until, well, last year. In, more or less October of 2022, Richard Allen is arrested based on basically nothing. In prison, yes, not jail. He was sent to prison because the local authorities said they couldn't guarantee his safety. So he was sent to prison, where he is in solitary confinement 23 hours a day. And he has deteriorated fast. In prison, the prosecution alleges that he made a confession through prison phone calls to his either mother or wife. But I said it before, I will say it again. A confession means nothing unless there are corroborating evidence. And so far, from just looking at the state case, nothing. They allege they found a shell casing on the ground between the girls that is consistent with a weapon that was in the possession of Mr. Allen. Here's the thing with that word. It means this kind of casing fits in that kind of gun, which for me is not evidence at all. And then a few months ago, a 137-page memo which pointed out that a lot of evidence that has been collected by the local police in Delphi doesn't match with Mr. Allen. They claimed then, his defense attorneys, that this was some form of Odinist cult behind it. And that piqued my interest because, well, ta-da. And hello everybody, thank you for being here. I hope this stream will go more smooth than yesterday's stream because that was bad. I even took it down because I know, forget it ever existed. And in that memo, the 137, they point out a lot of shady police work. They point out that in a crime scene, there was a rune written in one of the victims' blood. The sticks were placed upon the bodies that could be interpreted as runes, and even that the placement of the bodies has some significance within this Odinist cult. And it's very compelling. In this memo also, they point out that the defense lawyers have been prison guards have tried to listen in and even record their conversations with Mr. Allen. And these two prison guards happen to have Odinist patches on their uniform. All of a sudden, okay, what's going on? And as Mo used to say, man, bear, pig, but it does seem to have some substance. Now, the first judge who sent Mr. Allen off to prison, he was the one, can't remember his name, not important. He recused himself from the case due to, as he claimed, some form of threats against him, or he felt overly pressured from news media and stuff like that. And Mo isn't feeling well. So I've asked her, and said that if she isn't well, then she needs to rest, because she's had a rough week, and she deserves some rest. So no, Mo isn't here today, sadly. Where was the judge? For me, a judge that is that easily spooked shouldn't be a judge to begin with. But Mr. Allen was sent off to prison, where this confession happened, and his mental health and his health has deteriorated immensely. So that is the short story of it. Then something happened, and according to Judge Ghoul or Ghoul or whatever, I don't care, in a in-camera hearing, which we don't know the contents of because she put a seal over what was said in that, she decided more or less that the defense lawyers should be thrown out from the case because somebody leaked pictures of the crime scene. That someone was an acquaintance of one of the lawyers, not both, one of them. And the defense lawyers claimed that this person had access to their office and stole these and leaked these photos, which in my opinion is not nowhere enough near to have these people either recuse themselves or being recused from the case. Now she claims she got a verbal promise or whatever in that in-camera hearing that they would recuse themselves from the case. And so that hearing on September 19th never happened. Well, then she sat there on her podium. Jesus Christ. Sorry. Then she sat on the podium and said, well, Mr. Allen's defense lawyers have recused themselves from the case. Now, they claim not so much, at least one of them. And that is where we will get some. Let's see here. There it is. Sorry. Add to stage. Oh, of course. State of Indiana, County of Carroll, State of Indiana versus Richard and Allen. Verified notice of continuing representation. Comes now. Attorney Bradley A. Rodsey, counsel for Richard M. Allen, and in support of his verified notice of continuing representation, now swears and affirms as follows. On November 14th, 2022, counsel entered his appearance on behalf of Richard M. Allen. Counsel has engaged in the continuous representation of defendant Allen since that date and time. On October 12th, 2023, the court communicated with Prosecutor McClelland, Attorney Rossi, and Attorney Baldwin, at which time the court ordered Attorneys Rossi and Baldwin to cease work on Mr. Allen's case until the party was set to appear in court on October 19th. Sorry, October 19th, not September. The chilling effect of the court's emailed order was to essentially strip defendant Allen of his Sixth Amendment right to representation and essentially disarmed attorneys Rossi, Baldwin, and defendant Allen during the week leading up to the scheduled hearing, which was ordered by the court sua sponte. In an October 17th email, Attorney Rossi requested a conference to determine, quote, what we, as in the court, prosecutor, and defense counsel, are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on the record in open court, question. In response, the court ordered both the defense and prosecutor to appear in chambers on October 19th. On October 19th, attorneys Rossi and Baldwin appeared at the Allen County Courthouse in advance of the 2 p.m. hearing. This was prompted by Attorney Rossi requesting that the parties communicate in advance of the scheduled hearing. Attorneys Rossi and Baldwin appeared in chambers on the 19th at approximately 12:30 p.m., at which time the prosecution was present. Attorney Rossi is of the understanding that the court reported secured an audio recording of the in-chamber conference, which took place in 2 parts. The court first conducted business as it related to several pending motions by communicating with the parties and issued rulings on said motions. The court then read a prepared statement to Attorneys Rossi and Baldwin identifying various issues throughout the case through which Attorneys Rossi and Baldwin exercised gross negligence in carrying out their responsibilities as counsel for defendant Allen. The court then suggested that Rossi and Baldwin engage in a discussion outside of chambers regarding the allegations. Rossi and Baldwin asked for clarification, at which time the court communicated to attorneys Rossi and Baldwin that there were 2 distinct options. 1, either voluntarily withdraw their appearance and exit the courthouse in advance of the hearing, or 2, participate in a 2 p.m. hearing in the courtroom where a media camera was installed, the national media was present, and the law enforcement community was seated in the jury box directly behind the defense counsel table, at which time the court would read the prepared statement into record and then disqualify both Rossi and Baldwin in the presence of defendant Allen, his family, and the general public. I mean, this is bad. If what they say here is correct, then I don't know the local rules, but having something prepared, no, that's not how you do it, in my opinion. If they are accused of gross negligence, that should be a separate hearing, where prosecutor or judge formally places the allegations in front of the defense attorneys. The defense attorneys have a chance to reply. All of this should have been in an actual hearing, not just read out. This is not due process. If you are accused of something, you have the right to defend yourself. This Judge Ghoul, I don't care if her name is Ghoul. Ghoul is the proper name for that kind of conduct. She's stripping every part of the defense from due process, in my opinion. Let's continue. After waiting approximately 1/2 an hour for defendant Allen to arrive at the courthouse, Rossi and Baldwin communicated with Allen regarding the stark choice the court had offered in chambers. Allen reaffirmed his desire to move forward under the representation of Rossi and Baldwin. As of October 24th, Allen objects to the court's attempt to strip him of his current counsel, attorneys Rossi and Baldwin. Footnote. On October 12th, Rossi filed correspondence with the court. Said correspondence contained a letter dated October 11th, signed by defendant Allen, wherein defendant Allen acknowledged that he was aware of the issues regarding crime scene photos that were stolen from... Okay, that part is missing. Yeah. After speaking with Mr. Allen, Rossi and Baldwin then returned to chambers, at which time Rossi articulated to the court that the court had engaged in an ambush of defense counsel. I agree. Entirely void of due process, and that Rossi would withdraw his appearance. But that said withdrawal was not a voluntary withdrawal, because the court made it clear that if Attorney Rossi did not agree to withdraw, the court would publicly shame him in front of the world and his client before forcing him off the case by disqualifying him. And here comes a bit. Yeah. Welcome to the new YouTubes. They are rolling it out. The only thing I can... Either I don't monetize this at all, which means no memberships, no super chats, no nothing. Or the choice is to put ads in. And those are... I at least put in skippable ads. And yeah, so 5 seconds, and then you can remove them. That's the choices I have. Yeah, I know. Not all get ads, apparently, according to YouTube. I don't know. Have you asked me 3 months ago, I would have had answers. Now I have no clue what's going on with YouTube and their ad program, which definitely not is something I asked for. But these big tech channels, they want it because, as Mr. Big said in an interview, when he does his 1 hour videos, he put in ads every 3 to 5 minutes. I can ads before, ads after, then leave me the freak alone. Yeah. Where was I? Yeah, as Mr. Baldwin says, he's being forced. They are completely ambushing them with this. Nothing in advance, nothing. This is so beyond due process. It's ridiculous. All of the events in chambers occurred without any formal... Oh, sorry. There. So you can read it with me. All the events in chambers occurred without any formal allegations of contemptuous behavior by Rossi or Baldwin, without any pending pleadings requesting disqualification of defense counsel, and without any pending disciplinary complaints with the Indiana Supreme Court's Disciplinary Commission. In total, Rossi and Baldwin has practiced law in the state of Indiana for more than 50 years without a single substantiated finding of a disciplinary action against either. Thank you, Natal. Thank you so much. At no time while in chambers did the court ever articulate to either Attorney Rossi or Baldwin that their conduct compromised defendant Allen's defense in any way. In fact, Allen himself doesn't believe this to be the case. There are no bona fide facts or circumstances wherein Rossi engaged in gross negligence, nor was there any showing that any conduct by Rossi resulted in negative consequences to either party, i.e. defendant Allen. In sum, attorneys Rossi and Baldwin did nothing to compromise Richard M. Allen's defense. Attorney Rossi's oral acquiescence to withdraw his appearance as defendant Allen's attorneys was forced, coerced, and driven only by the circumstances created by the tribunal, which delivered two terrible options: quit or be shamed in public before being disqualified from representing Mr. Allen. The court's premeditated ambush of the defense placed attorneys Rossi and Baldwin and the client, Allen, in the most compromising position. The trial court stated intention to read a prepared statement criticizing defense counsel, creating an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light. This public statement and circumstance created by the trial court risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. The jury trial in this matter is set to commence on January 8th, 2024. This has been, since then, this has been, I think it's March now. A full 1 year and 3 months after the arrest of Allen. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in his case and trial. If, however, Rossi moves forward with his representation of defendant Allen, there will be no need for two newly appointed attorneys to dedicate hundreds and thousands of hours toward a mere review of the discovery, which continues to pour in as recent as late September. Yeah, I mean, we know that the defense have had serious issues getting discovery from the prosecution. In some cases, not until they found stuff out by themselves did the prosecution choose to hand it over. And it's so bad. I mean, I don't care if you think Mr. Allen is guilty or not. He deserves a fair trial. And in my opinion, Judge Ghoul and the prosecution does everything in their power to make sure he will. I'm not even sure they want him to stand trial, because his deterioration mentally and physically is so bad that I don't think I'm not sure he will survive until March. I really don't. And then the prosecution and the judge can say, well, technically solved, let's bury it, and so we can continue the circle jerk of judges and prosecutor in that county. There will be no need to marshal all the discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. Or yeah, we'll see. Yeah, for those who wonder, in about an hour, finally Friday starts, and this is Pink Bonnet edition. We'll explain that to you in the beginning of that one. Dun, dun, dun. A new defense team would likely result in a shifting of the strategy and approach of Allen's current defense team, which in turn would further delay and compromise Allen's defense. Finally, any successor lawyer would have that convenience of working with Rossi to become familiar with the subject matter in a much more efficient and fiscally responsible way. All these truths weigh in favor of Richard Allen's choice to maintain Rossi as his counsel of record. There are no circumstances under Rule 116 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rossi's representation of defendant Allen. Attorney Rossi notices up this court of his intention to move forward with the representation of defendant Allen until a final disposition of this matter. Yeah, and since then, the judge has appointed 2 new defense lawyers to Mr. Allen. And one of them has been in the media talking about this case, and in a negative matter towards Mr. Allen. The other one is a Facebook friend with the judge. Now here we come into the area, is this intentional, or is she an imbecile? Or is it a combination? Because there are a lot of eyes on this case and on this judge now. A lot of eyes. And with that knowledge, she still appoints a friend and a person who's negative to Allen. Now, intentional, or is she an imbecile, or both? I don't know. You tell me. One for intentional, that she does this to actively ruin the Allen's defense. 2, she's an imbecile, or 3, all of the above. Put it in the chat. Well, other things have happened also since then. Mr. Rizzo and Baldwin have said, we will represent Mr. Allen pro bono, so no need for public defender. The judge said, not direct quote, I can't do that to Mr. Allen. And so they are still not allowed to represent him. The judge won't allow it. Read between the lines, judge. This is so this is so bad. This is so damn bad judging. And let's see. If I can find her somewhere. No. No, not by a fast Google at least. But I don't know. It's infuriating. But now the defense lawyers have appealed to the Indiana State Court that, first of all, she put a seal on everything that was said in chambers. And Rossi and Baldwin said, you should have a look. That should not be sealed. She should be forced to hand it over. Now she doesn't want to. And this is what happened. Hold on. Dun, dun, dun. The Indiana Supreme Court orders judge in Delphi murders to hand over closed door transcript. So the Indiana Supreme Court wants to have a look at this. They don't care what Judge Ghoul has to say about that she doesn't want to reveal it, her misconduct, of course. but here is what WRTV Indianapolis says about this. The Indiana Supreme Court has ordered a special judge overseeing the Delphi murders case to hand over a transcript from the closed-door meeting between her and former defense attorneys. This week, the Supreme Court issued an order to a special judge, Fran Ghoul, to turn over a file of the conversations between herself and former defense attorneys for Richard Allen. The meeting prior to a scheduled hearing on October 19th, which has led to differing statements of what occurred, led to the dismissal of attorneys Brad Rossi and Andrew Baldwin. Richard Allen, the man charged with murder in connection to the deaths of Abby and Libby, requested a transcript earlier this week. According to Ghoul, the meeting led to the verbal withdrawal of Baldwin and eventually motion to withdraw from Rossi. Days later, Rossi filed a motion to continue his representation of Allen, claiming the court ambushed he and Baldwin, placing them in a compromising position. He also requested Ghoul to be removed from the case. And Ghoul should get a foot in the arse from being a judge at all. Her conduct here is apprehensible. It's vile. Since then, Allen, with new representation, has asked the Supreme Court to rule on Ghoul's placement over the case. They cited her lack of transparency. Yeah. And here it is. Let's see if I can. Yeah. State of Indiana, XRL, Richard Allen, versus Carroll Circuit Court et al. Respondents. Supreme Court case. Filed November 9th. So, yesterday. On November 6th, we issued an order setting a briefing schedule in this matter and ordering any response due by November 16th, 2023. And on November 8th, 2023, we issued an order requiring respondents to either respond to relator's motion for transcript or to provide the transcript itself by November 16th. That is the order to the judge. Get the papers over here. And on November 8th, we issued an order requiring respondents to either... On November 9th, we issued an order granting the Indiana Public Defender Council leave to appear as amicus curiae and file a brief. Respondents have now filed a motion for extension of time, requesting that the due date to respond to the petition for emergency writ, motion for transcript, and the Supreme Court's amicus brief be extended to November 27th. They want another week. Relator by counsel has filed an objection to the motion. Being duly advised, the court grants respondent's motion for extension of time to respond to petition for writ of mandamus and motion for transcript. Respondent's response brief and any supplemental records must be filed directly with the clerk of the Supreme Court on or before Monday, November 27th, 2023. No further request for extension will be granted. So that's the end date. They have, as for now, 17 days. No, any supplemental record must be submitted in the same format required for the record under Original Action Rule 3, C, and G. Done at Indianapolis, Indiana, November 9th, 2023. Chief Justice of Indiana, Loretta H. Rush. This means that Judge Ghoul has no choice. She has to produce the transcript or the recording, or both. and more or less get her ass to the Supreme Court to explain herself. So hopefully we finally get an answer to what went on in that chambers. And hopefully that also leads to, because in my opinion, this is clearly misconduct from the judge. Clearly. This is small town judge, small town prosecutor. It's our town, we can do what we want. But no. The justice system doesn't give two shits on a straw about who's the judge and who's the prosecutor. They care about the process. That's it. Now, judges are important, prosecutors are important, defense lawyers are important, but that's the position of the judge that's important. It's the position of a prosecutor that's important. It's the position being a defense lawyer. That's what's important, not the individuals. And it seems like Judge Ghoul thinks very highly of herself. This is my courtroom. I can run it any way I see fit. No, you harpy. You can't. The Constitution says so. Rules of conduct says so. It's remarkably now, this particular transcript should include what these allegations are that rises to the level of gross misconduct. And unless unless there's evidence, or unless there's something other than somebody stole the crime scene photos and leaked them. If that's it, that's not enough. It's nowhere near enough. I've seen court cases where defense attorney fell asleep. Still not misconduct. Still not a mistrial. Still not an appealable issue. This, in my opinion, is local judge, local prosecutor trying to cover up a complete butchery of an investigation. Well, it might not be so boring, at least not for me, but I'm a bit more, let's read this and have fun with it. It's remarkably bad conduct from the judge. Remarkably bad. And this is, if she gets thrown out from this case, all of a sudden you are on judge number 3, which is not good either. I don't know what the Supreme Court will do. We will find out on the 27th or the day after, which coincides with the planned start for the Young Thug trial. So we'll see how much of both I can cover. But I do know Mo in the deep end. Let's see. Jeez. This is Mo in the deep end. I know she has more information than I have and more videos. I just posted it in the chat. So yeah. But this again, it goes into what happened in what is happening now in the Murdoch case with the clerk of courts, and what happened to Zachariah Anderson, what happens in the Koberger, the Delphi 4 case. Don't hide, Jesus Christ, judges and prosecutors. Don't hide stuff from the public. Do that what you will, but don't hide stuff from the defense. And once you're caught with it, don't help judges, don't help the prosecution get rid of the defense lawyers. Now, for more information, go to Mo's channel. She has a lot of videos on the Delphi case. And yeah, this will be a lot shorter stream because I don't have Mo here to go back and forth with. So I just read the stuff, give you my opinions, and yeah, try to have you all informed. And I will redirect you to my Finally Friday stream. That will begin in roughly 40 minutes. It's the Pink Bonnet edition. If you wonder what a pink bonnet is, I will tell you. And I blame everything on Megan Fox, the reporter, who will appear on the stream in roughly 40 minutes. Together with, let's see here, who has Megan, Excited Utterance, Dave will probably show up. She's the Wisnut, Kaiser Pineapple. I've sent link to a bunch of people. As per usual, I don't really know who shows up. But yeah. But yeah, I will redirect you to that stream. And Baker will I hope he will show up at least. He was tired 2 hours ago, but yeah. Well, that's all I have. I will redirect you to the Finally Friday so we can get some fun in our lives. End of the work week stuff. But again, thank you for being here. Thank you for trusting me to give you the information you need about the justice system. All right. Have a good day. And I'll see you all in 40 minutes. All right. Bye-bye.